Good morning and welcome to the second part of our two-part webinar series discussing significant construction and adjudication cases of 2022. These webinars aim to cover key developments in construction and adjudication practice during 2022 and how these might affect your construction project disputes in 2023. So our webinar today will focus on our chosen top 5 adjudication cases of 2022. We will highlight the main facts and legal points from each and identify specific lessons to be aware of for construction contracts and claims. Our previous webinar, focusing on our chosen top 5 construction cases of 2022, was recorded and available to listen to again, and you will be sent details of the recordings of both these webinars after the event. If you would like to ask a question, please do so using the Q&A button at the bottom of your screen. In order to keep within time, we will be answering as many questions as we can at the end of the presentation rather than as we go along. And if we don't manage to get to your question, or if you are listening to a recording of this webinar, we would be happy to address any queries after the webinar by phone or email. And our contact details are on this next slide. So I am Nathaniel Buckingham, a partner specialising in construction and engineering dispute resolution. I was previously a chartered civil engineer working for one of the largest design consultancies, so have experience of the practical realities of construction, as well as the legal and dispute issues that can arise. I'm joined today by my colleague, Lisa Ambrose, a senior solicitor in our construction disputes team. Our team regularly advises on construction contract issues and disputes across a range of projects and clients. We therefore have a great deal of experience in litigation, arbitration, adjudication, and mediation, where our arguments have to reflect ever-evolving judicial approaches to construction law and contracts. I'll now pass you over to Lisa, who will run through the agenda for today's webinar.
Thanks, Nathaniel. So the first case we'll be discussing today is Northumbrian Water Limited against Doosan Enpure Limited. And this case provides a useful confirmation of the binding nature of adjudicators' decisions and of the use of Section 9 of the Arbitration Act. We will then move on to consider Van Oord against Dragados UK Limited, which is a case that demonstrates the importance of an adjudicator providing opportunity to both parties to comment on important points before deciding them. The third case we will discuss is Bilton and Johnson Building Co Limited against Three Rivers Property Investments, which decided whether an adjudicator is entitled to make a decision which is derived from party submissions, even though not identical to what was submitted. Our fourth case is Reakshore against Red Key Concepts. In it, the court provided guidance on the strategic use of Part 8 claims to resist payment of damages awarded by an adjudicator. The fifth and final case we will consider today is Sefton Metropolitan Borough Council against Allenbuild Limited, which also considered the use of Section 9 of the Arbitration Act, although on a different basis, and which emphasises the importance of drafting notices of dissatisfaction carefully.
So our first adjudication case is Northumbrian Water versus Doosan Enpure. And I'll give some background to this case first of all. So Northumbrian Water, the employer, engaged Doosan Enpure, the contractor, to design and construct an upgrade to water treatment works under NEC 3 option C conditions. The parties agreed that option W2 should apply, which requires that disputes be referred to an adjudicator whose decision was final and binding on the parties unless and until revised by an arbitration tribunal. Now, disputes arose which related to cost overruns, delays, and quality of work. The employer terminated the contract. That termination was disputed by the contractor, who submitted that the employer was in repudiatory breach. Now, repudiatory breach means a significant breach which would allow the contractor, in turn, to actually terminate the contract. The dispute was referred to adjudication, which found in favour of the employer that the termination was valid and granting various significant payments from the contractor. The contractor gave a notice of dissatisfaction, a requirement before arbitration, that it was dissatisfied with the adjudicator's decision, save for certain paragraphs, and that it intended to refer those matters to arbitration for final determination. Meanwhile, because the contractor hadn't paid the adjudication sums, the employer commenced court proceedings to enforce the adjudication decision. The employer submitted in court that the adjudicator's decision was valid and should be enforced. They said that the contractor had not raised any jurisdictional challenges prior to or during the adjudication. They had not raised any issues of natural justice in the notice of dissatisfaction and had only indicated parts of the decision were to be referred for final determination, indicating that they, the contractor, accepted the validity of the decision. The contractor, on the other hand, argued that it was entitled to a stay, that's a pause, of the enforcement proceedings under Section 9 of the Arbitration Act, because the adjudication enforcement claim was a dispute arising under or in connection with his contract within the dispute resolution clause, which therefore had to be referred to arbitration, and that the enforceability of the adjudicator's decision was a matter for the arbitration tribunal rather than court. Now, in its judgment, the TCC, the Technology Court in England, held that having participated in the adjudication without raising any jurisdiction challenge, either specifically or more generally, it was too late for the contractor to raise such a challenge now, and it was deemed to have waived any right to do so. General non-admissions and reservations as to jurisdiction were set out in the notice of dissatisfaction, but these were too vague to be effective. The contractor had accepted parts of the adjudication decision on the merits and did not identify any breach of the rules of natural justice or want of jurisdiction. The courts generally take a robust approach to adjudication enforcement, regardless of errors of procedure, fact, or law, unless the adjudicator has acted in excess of jurisdiction or in serious breach of the rules of natural justice. Subject to its application for a Section 9 stay, the court said that the contractor had no defence to the application for enforcement of the adjudication decision, and the employer was entitled to summary judgment. Now, secondly, in addressing the Section 9 stay, the TCC held that no stay was to be granted under Section 9, although Clause W2 defines dispute in very broad terms and is sufficiently wide to include whether the adjudicator lacked jurisdiction or breached natural justice. The contractor had lost the right to challenge the validity of the adjudication decision in court or in arbitration, although, of course, it had retained the right to refer the underlying disputed issues to arbitration. On that basis, the court said that the effectiveness of, and therefore enforcement of, the adjudication decision was not a matter which was in dispute under the contract and which was to be referred to arbitration. And so Section 9 simply was not engaged. And they went on to say that regardless of the scope of any reference to arbitration, the parties had expressly agreed that the adjudication decision would be binding on a temporary interim basis, pending any revision in arbitration. The mere fact that the decision may later be revised in arbitration is not a good reason to not grant summary judgment, and that's what the court decided to do. Now, this case again highlights the strict approach of the courts to parties who have contractually agreed to be bound by the decision of an adjudicator and have participated in an adjudication without raising any jurisdictional challenge. The courts will expect parties to abide by the decision of an adjudicator, which will be held as enforceable, even if the underlying issues might ultimately be referred to an arbitrator. And in the meantime, the decision of the adjudicator will be binding and enforceable in court. In this case, the contractor had not raised any issues with jurisdiction or natural justice during the adjudication, nor had they adequately challenged the decision within 4 weeks in their notice of dissatisfaction. So in such circumstances, the courts will simply be prepared to enforce the adjudicator's decision, rather than that enforcement having to be referred to arbitration.
So the second case that we are going to look at today is Van Oord UK Limited against Dragados UK Limited. The Court of Session considered whether an adjudicator's decision to award an extension of time for completion and related costs due to a compensation event was enforceable, where it had been reached on a basis not discussed with the parties. You might be familiar with the other Van Oord cases, particularly the case in relation to the interpretation of the clause 10.1 in NEC contracts, which obliges parties to act in a spirit of mutual trust and cooperation, and which reached the inner house of the Court of Session last year. However, this is a different case concerning adjudication enforcement. So Van Oord carried out subcontract work for Dragados on the harbour expansion project in Aberdeen under NEC conditions. Almost 2 years after entering into the subcontract, Dragados gave Van Oord notice to terminate the subcontract. There were various disputes between the parties, and these led to 7 adjudications. In the 6th adjudication, Van Oord argued that it had been denied access to carry out open key excavation works due to Dragados's lack of progress in carrying out piling works, causing critical delay. On expert evidence, Van Oord contended that as a result, and by reference to a particular baseline programme, it had suffered critical delay from the 2nd of August 2019. Dragados argued that it was Van Oord's failure to start certain works on time that caused the delay, and founded on a different baseline programme. However, both parties' experts had considered and rejected a programme from March 2019 as the baseline programme. The adjudicator found in favour of Van Oord, awarding it an extension of time for completion and delay-related costs for a specific compensation event. However, crucially, the adjudicator did so on the basis of the March 2019 programme and a critical date for the particular compensation event of the 31st of July 2019. Neither that date nor the consequences of it being the critical date was advanced by or discussed with either party during the adjudication. So in considering whether this rendered the adjudicator's decision unenforceable, Dragados argued the adjudicator should have told the parties what he was contemplating so that they could address him on it. If that had happened, Dragados would have argued that the matter was time-barred because based on the adjudicator's chosen date of the 31st of July 2019, the particular compensation event had not been notified within the 7-week period required by the subcontract. If correct, this would have been a complete defence and was therefore material. Dragados argued that this was a breach of natural justice, meaning it was denied a fair hearing during the adjudication. Van Oord argued that the adjudicator was entitled to adopt an intermediate position between the parties' respective cases, and that Dragados was aware of Van Oord's position that the delay in question had occurred before the 2nd of August 2019. It therefore should have made its time bar argument in the adjudication, and in fact, it already had. In its decision, the court said that the line between an adjudicator going off on a frolic of their own and making legitimate use of their experience to analyse material which has been lodged and commented on by parties is not an easy one to draw. It must be remembered that a decision by an adjudicator on the second side of the line, that is, making legitimate use of their experience to analyse material, will be enforced, even if it is wrong. It was therefore irrelevant whether the adjudicator was right or wrong to take the 31st of July 2019 as a critical date. The reasoning was unclear, but that did not mean it was unfair. Also, the adjudicator had not made his decision through his own inquiries, but on the material provided to him by the parties. However, the parties could not have anticipated the adjudicator's decision that 31st of July was the critical date, and it was not Dragados's sole complaint in the court action that the adjudicator had adopted the March 2019 programme. Rather, the adjudicator had adopted the 31st of July critical date, which was different to and earlier than argued for the pursuer, and it was not an intermediate position. Fairness demanded that the adjudicator had at least given the parties a chance to address him on this during the adjudication. The court agreed that whether Dragados's potential time bar argument in respect of the adjudicator's chosen date of the 31st of July would have changed the decision or not didn't matter. What mattered was that Dragados was deprived of the opportunity of making the argument. The court therefore concluded that the adjudicator had not given parties fair opportunity to comment, and that the adjudication decision could not stand and was ordered to be set aside. So what can we take away from this decision? As mentioned by Lord Braid in his judgment, the courts will in general summarily enforce decisions of adjudicators, and challenges to decisions on the basis of a breach of natural justice will only succeed in the plainest of cases. However, the court obviously decided that this was such a case. The case highlights the importance of an adjudicator allowing both parties the opportunity to comment on points considered significant by the adjudicator, which parties were not aware of or did not argue. This is to ensure that parties have a fair hearing in the adjudication. We often see adjudicators providing a list of relevant issues and inviting any final comments ahead of their decision, just to avoid this sort of issue. Parties should therefore review and consider adjudication decisions carefully and not be deterred from challenging the decision if there is a clear failure to allow a fair hearing. A favourable adjudication outcome based on a point not argued might initially seem attractive for a claimant, but an inability to enforce that outcome will undermine the time and cost spent pursuing the adjudication.
Okay, our third case is Bilton and Johnson versus Three Rivers Property Investment. So in this case, the claimant had successfully tendered to refurbish the defendant's industrial estate for a sum of 1.9 million. And the form of tender was issued by the defendant and accepted in August 2018 by the claimant, with a formal JCT design and build contract to follow. The tender contract provided for LDs per section of 2,500 per week. The JCT contract was then issued and signed in January 2019. In contrast to the tender contract, the JCT contract set LDs at 2,500 per week in total, not per section per week. The project suffered delays and the defendant withheld £234,000 in liquidated damages from the claimant on the basis of the tender contract amount. In the adjudication proceedings, the claimant argued that the JCT contract was the sole formal contract between the parties. The defendant argued that it was the tender contract. Alternatively, it argued that the JCT contract's liquidated damages clause was clearly a mistake that failed to be rectified. The adjudicator concluded that the tender contract was validly formed, but was then superseded by the JCT contract. The adjudicator therefore ordered the defendant to repay the LDs. The adjudicator rejected the rectification argument, finding that the higher rate of liquidated damages was disproportionate and would have amounted to a penalty in any event, so that in any event he would not have been in a position to rectify the JCT contract. In court, the defendant argued that the adjudicator had acted in breach of natural justice by firstly, identifying the applicable contract terms on a basis that was not advanced by either party, and secondly, taking a restrictive view of his jurisdiction regarding the rectification defence. The TCC rejected the application. The court found that the adjudicator had not acted in breach of natural justice in finding that both contracts were validly formed, with the JCT contract superseding the tender contract. Although that precise reasoning for finding in favour of the JCT contract was not put forward by either party, it was plainly a case where the adjudicator's reasoning was derived from the parties' submissions and did not have to be put to the parties in advance of his decision. It was not a case where he had derived a new and different basis for the claim and failed to put it to the defendant. The defendant had had a full opportunity to make submissions as to which contractual terms applied and why. It was not taken by surprise and prevented from making any argument by the adjudicator's approach. Accordingly, there was no unfairness regarding the adjudicator's conclusion and how he had arrived at that conclusion on the applicable contract terms. On the rectification defence, the court found that the adjudicator had not acted unfairly in the way he addressed the rectification defence. His basis for rejecting the defence was not that he had no jurisdiction to rectify the JCT contract, rather it was that the defendant would not have been entitled to withhold the liquidated damages at the higher rate in advance of the contract being rectified, and were the higher rate amounted to an enforceable penalty. It was in a further and in any event statement that he decided that if the question of jurisdiction had arisen, he would have concluded that he was not empowered to order rectification. So whether this reasoning in rejecting the rectification defence was correct as a matter of law was not material to whether his decision should be enforced. Only a deliberate failure on an adjudicator's part to address the rectification defence would have rendered the decision unenforceable. So what can we take away from this case? Obviously, in contrast to the Van Oord case, the court decided to enforce the adjudicator's decision here, where although the adjudicator's precise reasoning in his decision was not put forward by either party, the adjudicator had derived the reasoning from the party's submissions. These cases together really do emphasize that line mentioned by Lord Braid between an adjudicator going off on a frolic of their own and making legitimate use of their experience to analyze the material which has been lodged and commented on by parties. And that's a very fine line.
So our fourth case today is Reakshore against Red Key Concepts. This is another English case about English procedure, but it is important for those who are involved in English projects and those interested in how the courts tackle tactical approaches to overturning adjudications. So just to give a bit of background on this case, Reakshore employed Red Key Concepts to construct a 6-storey tower block in Kent under a JCT contract. The contractual completion was expected to take place in May 2021. However, Red Key suspended works in August 2021 on the grounds that the tower block had been built 1.5 metres taller than the height approved in the planning permission. This pushed back the completion date to October 2021, prompting Reakshore to claim liquidated damages at adjudication. The adjudicator decided that Red Key should not have paused works without Reakshore's instructions, regardless of the pending revision to the planning permission. Reakshore was awarded £280,000 in liquidated damages for the delayed completion. However, Red Key refused to pay, leading Reakshore to seek enforcement of the adjudicator's decision at the County Court in London by way of a Part 7 claim. In turn, Red Key raised a Part 8 claim, resisting enforcement of the adjudicator's decision. So just to give a brief comment on Part 8 claims, under the civil procedure rules in England and Wales, Part 8 claims are an alternative way of raising court actions to the standard Part 7 route. Part 8 claims can be utilised where there is no substantial dispute over matters of fact and are designed to be shorter, simpler and less adversarial than the Part 7 process. Part 8 claims are often raised as a cross-claim in response to Part 7 actions which are enforcing adjudication decisions. So in this court action, Red Key asked the court to declare, without revised planning permission, it was unable to continue works and was entitled to suspend the works under the contract, and further, that the adjudicator's decision to award liquidated damages was unenforceable. In its judgment, the court followed the case of Hutton Construction against Wilson Properties, which decided that an adjudicator's decision can only be challenged via the Part 8 procedure in very limited circumstances. Hutton held that the party resisting enforcement proceedings must show that firstly, it contests a short and self-contained issue that arose in the adjudication. Secondly, that the issue requires no oral evidence or elaboration, except that which is provided in the enforcement hearing. And thirdly, that the issue is one which would be unconscionable for the court to ignore. In the Reakshore case, the two key matters were whether it was reasonable for Red Key to suspend works given the height issue, and whether this issue was in fact the cause of delay. The court found that both of these matters involved questions of fact, making them unsuitable for a Part 8 claim. The judge highlighted that the height of the building might not have been the true reason for the suspension of the works, given that the local authority did not measure the tower block until 2 months after Red Key had demobilised from site. The judge also found that there was no clear-cut issue from which could be understood that the adjudicator was obviously wrong to decide that the liquidated damages were due. Reakshore was therefore awarded summary judgment. The judge criticised Red Key for improperly choosing Part 8 procedure to gain tactical advantage, namely being able to make changes to their claim the day before the hearing without the risk of facing defences. The court ordered Red Key to pay £77,000 in costs on an indemnity basis. So, points to note from this case, although it is a popular tactic, the English courts are alive to the strategic use of Part 8 claims to resist enforcement of adjudication decisions, and will react to the improper use of this procedure by ordering significant costs against the party at fault. Cost implications can be high, compared with the short-term gain of resisting payment of an adjudication decision. The courts will only interfere with the decision of an adjudicator in limited circumstances. The correct approach to challenge and enforcement would be to utilise Part 7 procedure, which allows for a detailed consideration of the facts. However, this would require, in this case, a separate Part 7 claim to have been raised, and the adjudication decision would likely have to have been complied with in the meantime before raising such an action.
So our last case is Sefton Metropolitan Borough Council against Allenbuild. And this relates to a claim for alleged defects under NEC2 contract for the construction and maintenance of a water-based theme park. The NBC of Sefton obtained an award at adjudication for 2.2 million, and Allenbuild, the contractor, sought to challenge that enforcement. Now, the Allenbuild, the contractor, sought to challenge enforcement of the adjudicator's decision and had preserved its position by issuing a notice of dissatisfaction. Now, their notice had been drafted very widely and included dissatisfaction with the entirety of the adjudicator's decision, including all conclusions, reasonings, and decisions. Now, the council sought enforcement of the adjudicator's award, while again Allenbuild sought to stay the enforcement proceedings. Now, again, under NEC2, the decision of an adjudicator applies unless it's revised by a tribunal, and which is either a decision of a court or a decision at arbitration. If the dispute relates to an NEC contract, a notice of dissatisfaction must be served within a stated period of time if it's to be challenged. Otherwise, the adjudication decision is time barred. Now, in its judgment in respect of the notice of dissatisfaction, the court considered that when drafting a notice of dissatisfaction, the issue of validity of an adjudicator's decision is of fundamentally different character from the substantive merits, and a notice of dissatisfaction, needs to make it clear whether it's a challenge to the validity of an adjudicator's decision on jurisdictional grounds, instead of or in addition to a challenge to the substantive merits. Now, the words used by Allenbuild did not make this clear because it was just simply too widely drafted, a catch-all notice rather than specifics. The court held that there's no need for the notice of dissatisfaction to descend into details of the substantive challenge, but they've got to make it clear and crystal clear what it is that they're challenging. So the key takeaways here is the notices of dissatisfaction under NEC should be drafted very carefully and clearly and with consideration of all the issues, not just simply a wide and catch-all notice. Challenges to the adjudicator's jurisdiction or the substantive merits of the decision should be separated out in any notice of dissatisfaction. It's fine to address both, but just make sure you're addressing them separately. And finally, take care to check the rules of adjudication that apply to your dispute, particularly at enforcement stage.
So just to round up some of the main points that can be taken from our 5 adjudication cases of 2022. Firstly, courts will expect parties to abide by the decision of an adjudicator, which will be held as enforceable, even if the underlying issues might ultimately be referred to an arbitrator, and in the meantime, the decision will be binding. However, it is important for an adjudicator to allow both parties the opportunity to comment on points considered significant by that adjudicator, which the parties were not aware of or did not argue, to ensure that the parties have a fair hearing. An adjudicator is also entitled to make a decision which is derived from parties' submissions, even where it's not identical to what's been submitted. But an adjudicator cannot go on a frolic on their own, as the line may not always be clear and be fact dependent. The courts are also alive to the strategic use of Part 8 claims to resist enforcement and will react to the improper use of procedure by ordering significant costs against the party at fault. Cost implications can be high compared with the short-term gain of resisting payment of an adjudication decision. The courts will also only interfere with the decision of an adjudicator in limited circumstances, and the correct approach to challenge the substance of a decision in enforcement would be to utilise the Part 7 procedure, which allows for a detailed consideration of the facts. And finally, notices of dissatisfaction under NEC contracts in particular should be drafted very carefully and with consideration of all of the issues. The grounds of challenge to the substantive merits of an adjudication decision do not need to be set out in detail, although it is worth taking a cautious approach.
So we've now come to the end of today's webinar. We do hope that has been an informative look at some of the important adjudication cases decided in 2022. We are at 10:30, but we will just try and answer a couple of questions that have come in, perhaps, for those that do want to stay with us. I'm just reading the questions here. So the first question, one of the first questions is, how do you decide if an adjudicator has derived his reasoning from the parties or went off on a frolic when considering whether to challenge a decision? I mean, that's a good question, and obviously the two contrasting cases here, Van Oord and the Bilton case, the courts arrived at different decisions. I mean, it really does depend on the particular decision reached by the adjudicator and the arguments put forward. So what we would say is always read the decision carefully, but alongside the submissions. And one thing people sometimes forget to do is consider the decision against the other side's submissions as well, rather than just your own. You might think they've not come to a decision that doesn't relate to your submissions, but it might be because it relates to the other side's submissions. And where an adjudicator's clearly referred to submissions and walked through the reasoning that arises from those submissions, it's likely the decision will be fine. But if you just simply cannot find the connection between any of the submissions and the decision, then it might be worth challenging. And obviously, just one word of caution: if you do choose to challenge an adjudicator's decision, as we've just demonstrated by looking at these two cases, the courts can be reluctant to overturn them. So the bar is high. So just be aware of that. That doesn't mean it's not worth challenging in some cases or for tactical and strategic reasons, but just be aware of the high bar that you've got to overcome. And I suppose there may well be adjudicators on this call. If you are an adjudicator and you are worried that you might be straying beyond the submissions, then it is often useful to issue a list of issues for final comments to help to make sure that you are giving everybody an opportunity to comment on the thinking and the direction of your decision. That ought to cut out any or can help to cut out any challenges. I think maybe I'll just answer one more question, which is, should the use of Part 8 cross claims to defend an adjudication enforcement action under Part 7 be avoided? I mean, Lisa, that was your case, and I know you've had some experience of that, so I'll let you answer that one.
Thank you. So again, it depends on the particular circumstances of the case. We're not saying that Part 8 claims shouldn't be used at all. But as mentioned earlier, the courts are alive to the use of these types of claims to strategically avoid complying with the adjudication decision, or at least postponing it. If there is genuinely a short and self-contained issue which doesn't require any evidence or elaboration, and the court genuinely can't ignore it, then the Part 8 procedure can be used and should be used. However, such issues are unlikely to be all that common. And so what we would always say is just consider the drastic consequences that can be awarded if the Part 8 claim is used incorrectly.
Great, thank you. And thanks for those good questions. If there are any further questions, I think that's all we'll answer now, but if there are any further questions, just please submit them using the button on your screens, and we'll get those and come back to you, or just contact us by email, and our details are on the screen there. As I said at the beginning, an on-demand version of this webinar will shortly be sent to you all should you wish to share it or watch it again at your convenience. So finally, from Lisa and I, just a thank you all for listening, and we hope you will join us again at some of our future webinars later in the year. Thank you very much.
Thank you.